Good morning, ladies and gentlemen. Welcome and thank you for joining us today. My name is Georg Kresbach. I'm partner at Theiss in the Vienna office. Today with me, I have Sorin Dumitru from our Bucharest office in Romania and Peter Ihas from our office in Budapest, Hungary. The topic of today's webinar is the Omnibus Directive and what we have observed so far a bit more than 6 months after the implementation deadline. As you may know, this directive has to be implemented and applied by member states from 28th of May 2022. Before we start, a couple of housekeeping points. We'll have a Q&A session at the end. However, we invite you to submit your questions via the chat function you can see on the right side of your screen at any time, please. This event will be recorded and shared via our website and social media. Lastly, after this presentation, this webinar, we will send out the slides of the presentation so that you can study after on at home. Now, with no further ado, we are starting with the presentation. Topics of our today's webinar are the directive overview, compliance, online marketplaces, new rules for online shops, new fines and sanctions. At the very end, we'll present you some cases, lesson learned from the practice. So, the goal of this Omnibus Directive is the better enforcement and modernization of Union consumer protection rules. It means Omnibus Directive, Omnibus, quite a bit a strange title. Omnibus, it shall express that nearly all of existing previous consumer protection rules in the European Union has been modified by this directive, such as the directive on unfair terms in consumer contracts, the consumer protection in the indication of prices and of products offered to consumers, then the directive dealing with unfair business to consumer commercial practices, and lastly, the directive on consumer rights. All these four directives has been amended by the Omnibus Directive, what makes this directive a little bit hard to read through, because you will find everywhere amendments of the directives as mentioned before. So what about transposition status in Central and Eastern Europe, where our firm Theiss is running the offices? You can see on this slide that nearly almost all countries have already implemented the directive, with one exception. Slovak Republic is still discussing in the parliament the text for implementing this Omnibus Directive. Any other country from Poland, Czech Republic, Austria, Hungary, Romania, Bulgaria, Croatia, and Slovenia have already implemented. Good. After this very brief introduction, I may now hand over to my colleague Peter. He will present compliance for digital goods and services.
Very many thanks, Georg, for the introduction, and a warm welcome to our guests and listeners. My name is Peter Ihas, a Senior Associate from the Budapest office of Theiss, and in the coming block, I'll be walking you through the main changes brought about by the Omnibus Directive. Now, as we know, the directive itself aims to give consumers more rights and greater protection, and thereby amending the flurry of already existing directives. The Unfair Contract Terms Directive, the Price Indication Directive, Unfair Commercial Practices Directive, and the Consumer Rights Directive. And the topics we'll be going through will be mainly these, and we've arranged the topics and the slides coming basically in this order. So these changes are set to regulate and provide adequate levels of protection and remedies to consumers who have become considerably more active in the e-commerce market, and as a result became more exposed to experiencing unlawful commercial practices or are provided insufficient information to make knowledgeable and informed commercial decisions. So, that being said, let's jump in and with the initial slide. So we're just a good summary of what to expect here. We've been introduced with new definitions for digital services, content, online marketplaces, and online marketplace providers, thereby basically allowing the already existing consumer protection regulations to cater for and regulate these new platforms of commerce. We are seeing and experiencing some extended visual mechanics that now include digital goods, services, and also those contracts where there's no actual quid pro quo in terms of fees, but data is provided in exchange. Obligations on traders and manufacturers are now also, with respect to maintaining those warranty requirements and those characteristic requirements of goods that are also digital, not just for tangible and physical goods. Requirement to traders. They will have to be more transparent in terms of their pricing. They will have to be more transparent in terms of the information they are providing to consumers through their platforms and in the course of their operation. And also disclose mechanics that are used to manipulate product rankings, and manipulate in the sense of using any automated algorithms that cater or try to personalize product rankings when consumers are searching on these platforms. There's also a requirement for combating misleading or fake reviews. We'll touch on that in the coming slides. A very interesting and I think a most important part is that there's a recognition of the issues of dual quality products in jurisdictions across the EU. And so now traders will have to be very careful and consider those requirements that allow them or disallow them to market products as identical in case where those goods have some kind of quality difference. And of course, there's the introduction of data privacy compliance elements. And let's move on to the next slide. What to expect practically as a provider and as a market player. There will definitely be increased scrutiny for e-commerce players, and definitely an increased consumer rights enforcement, which we are already seeing, at least in our local jurisdiction, even with the Omnibus Directive only coming into force late May last year. And definitely there will be some further fine-tuning of the directive. This is already provided with the acceptance of the directive, saying that the dual quality products regulation may see some additional updates. Moving on to the next slide. One of the most important new definitions and elements is the definition of the online marketplace. And if you take a closer look, we see that the EU Commission has made great efforts to include all existing platforms and communication channels where e-commerce can take place. So it includes software, websites, or applications running on websites, meaning it doesn't really matter if it's a website operated e-commerce platform or it's a mobile application. The same regulations, same requirements will apply. And also including not just tangible physical goods, but also digital ones. Yes, and one very important thing to mention is that size doesn't really matter here. Be it a big player on the market or being one that's selling only locally, the requirements will equally apply, and this will have to be considered. Yes, the information requirements that the Omnibus Directive requires and prescribes is that now traders will have to take even more care of providing adequate contact details and means of communication, and not just only emails and telephone numbers, but if there's any automated service, any any support line, AI driven or just someone sitting behind a desk somewhere far away, those means will have to be made very clearly available to the consumer, and also the consumer will have to be informed of what they can expect in terms of help and service. This also applies as a general requirement. The terms and conditions applied by these players on the market will definitely have to be revised and made sure that these terms become as easy to understand as possible. The whole, from the time when the consumer enters the marketplace and until the time the goods are purchased and those are sent into delivery, and even afterwards, of course. But the whole process itself must be very clear, transparent, and allow the consumer to gauge and understand what they can expect in terms of the goods they will be purchasing. Very interesting turn of events with respect to the digital goods is that the requirements of interoperability and functionality, compatibility of these products, that's been already foreshadowed by the Digital Content Directive, the DCD, coming into force somewhat earlier, is that these digital goods will have to be able to work together and operate together with those platforms, those devices for which they are purchased. And this also means that system requirements and the optimal running conditions of these, for example, programs, will have to be very clearly provided to the consumer. Otherwise, there's an issue of the consumer not having enough knowledge and purchasing goods that maybe would not be able to run on his or her device. And of course, the question whether the information regarding most important to online marketplaces, the issue of presenting if the marketplace itself is selling the product, or if it's a trader in contracting with the platform service provider is selling the product itself. So there has to be a clear distinction has to be made on who is actually selling the product itself, who the consumer can contact, who's taking on what liabilities, and it's also very important to state if the trader itself is a professional trader or a private individual, because the consumer protection regulations will not equally apply to those players, private individual being exempted, and so the level of protection granted by a private individual is not equal to one by a professional trader. And of course, we'll touch on that with our case study, but liabilities and responsibilities between online marketplaces and the traders will have to be very clearly defined. Yes, price indications is a part of the Price Indication Directive amendment. Just the whole basis of it is that consumers will have to be knowledgeable about the base price on which any price decrease or any promotion is applied. And how the regulations try to combat that is that the original base price will have to be applied in the preceding 30 days, will have to be also displayed next to the price that is affected by the reduction. So basically the consumer will have to see what was the original price on which this reduction was applied. If there's no price that is available, so the product is not in on the market for the mentioned 30-day period, then the previous 15 days will be applicable. But of course, it's self-explanatory. Whatever price it was originally marketed on the product itself, that will have to be displayed. And of course, any automated decision-making processes will have to also be disclosed on the website itself. Moving on to the next one, withdrawal rights. I think what's very important to note here is that withdrawal rights now not only apply to those products that have been paid for with cash, but products that have been paid for with personal data. And very interesting, those digital services that require no upfront payment, only a registration or a personal profile to be created, and then allowed to use the services will have to allow withdrawal rights to be exercised. And if such withdrawal rights are exercised, personal data of the user will have to be adequately managed and deleted, save for those that the law actually allows. What's also quite interesting with the digital goods and services and content coming into the picture is that the withdrawal rights for digital goods have also received some detailed withdrawal provisions. Those that and digital content on non-durable mediums, such as, for example, a DVD, expires already at the beginning of the performance of the contract. And in case a consideration is agreed, then there has to be an express consent from the consumer to allow that withdrawal right to cease. There were also some minor updates to model withdrawal forms, which have been rolled out, for example, in Hungary already to the local legislation and can be accessed through your local regulations and are definitely usable to update your now existing GTCs. In terms of unfair trade practices, as already mentioned, the general terms must be very clear and very concise, allowing the consumer to guide itself through the whole the process of the purchase, and pricing mechanics must also be very transparent, as mentioned, with respect to the price indications and reductions. Customer reviews used for marketing products that are not the ones, the third-party reviews that outside parties can add to a specific product, but what are actually used as marketing elements, must be clearly verified, and there has to be definitely great focus on not fabricating user reviews, because that can draw with itself some competition issues. Moving on to the next slide, the marketing of dual quality products. Here we have to know that the marketing of dual quality product is when some products are marketed as identical, but in fact they are lacking, or there are some differences in their general characteristics. And what traders will have to do in this sense is they will have to, of course, review their whole product palette if this is a concern that may arise, and evaluate whether these products have any different composition, quality, or characteristics to other products in question marketed around the EU, and assess whether these reasons, whether these changes in characteristics can be justified or not. Because if not, then it should be considered to make appropriate steps to not to mislead consumers of them believing that these products are actually the same, but in fact there are differences, unless there are reasonable and logical and well substantiated reasons for these products to be marketed identical, but in fact being somewhat different, for example, just to comply with local regulatory requirements. Yes, and coming back to the fake reviews, as mentioned, when reviews are used for marketing purposes, next to products or displayed on products, that's definitely something the traders will have to very carefully review and verify these reviews, and these cannot be fabricated or come from their own marketing department. But at the same time, any action or any steps taken to mitigate or remove third-party reviews attached or displayed on the websites, appropriate parts of the website of a platform provider, must also be constantly monitored, and also no steps can be taken in order to hunt down and delete negative reviews, or allow any false review verification claims, or there should be no concealed paid endorsements or rankings, because these again will bring about serious unfair trade practices issues. And in general, what to expect in terms of authority practice, the what we see already in Hungary, for example, is that possibility of authorities joining forces to allow bigger capacities and a sweeping review of the e-commerce marketplace. As mentioned, the surge of e-commerce and the prominence of this new marketing channel is definitely caught the attention of authorities, and now what we see, for example, in Hungary, is that the competition authority is already freeing up its capacities to work together with local consumer protection authorities to investigate cases of national relevance, and also the consumer protection authorities are actively checking compliance with the Omnibus Directive, mainly in terms of checking e-commerce platforms, e-commerce players' terms and conditions, if they comply, as well as not just terms and conditions, but generally how they operate, how they manage withdrawal rights, how they manage shipping, how their page is laid out, how consumers are informed when they are clicking through the page, how the whole process of purchase goes. So definitely, the Omnibus Directive is not just about renewing terms and conditions; it's also renewing and reviewing the complete practice of e-commerce providers all around the member states. Many thanks. Handing over to Sorin.
Thank you so much, Peter, for your very nice presentation. I will take it from here and talk about fines. So a quick introduction of myself. My name is Sorin Dumitru, and I'm a senior associate with Wolf Theiss Bucharest. And I will be walking you along the new provisions in terms of fines and sanctions under the Omnibus Directive. So to quickly jump in, the main issue is that when doing a fitness test of the existing consumer protection legislation, the Commission observed that the rules which establish the value of the fines and the computation methods thereof in relation to consumer protection are very different when it comes to the national legislation of each member state. For example, in certain member states, the value of the fines are much lower than in other member states, meaning that a coordinated approach to the matter would be necessary for the purposes of deterring the establishment of companies in low fine states, which may affect consumer rights with an EU-wide dimension. At that time, when the Commission was analyzing the need for a reform in the consumer protection legislation, 13 out of 17 member states and all the consumer protection organizations considered that the value of fines needs to be reviewed. One of the aspects that was very interesting for me is that when member states and the authorities of member states analyze the value of a fine that should be handed down to a company, they do not necessarily take into account whether that offense actually occurred, had effects in multiple member states. Yeah, although as we will see in the next slides, this is something that the mechanism is already in place and it works in certain parts. So moving on to the next slides, please. You will see here, so in order to establish a fine and to apply it, first the authorities that will be issuing it need to find the offense, right? So this has been done for a number of years now. It has started, as you can see, in 2007. And there are these so-called sweeps, which the EU performs, and they target certain sectors which are of interest, and they are quite broad, as you can see from this slide. With a very important mention that after a sweep, normally companies do comply with the requirements of consumer protection legislation and the requirements of the consumer protection authorities. Going on to the further slide, please, if we can. I can show you a further, okay. So as you can see here, the latest sweep that was made was actually in December 2022, when the EU actually monitored the prices and the practices of online shops in relation to Black Friday. Black Friday is a huge event that is widespread in Europe, and there are several techniques that have been used successfully in the past so the prices are not necessarily correct, the discounts are not necessarily correct, and these statistics that you can see on the screen speak for themselves. So 1 out of 4 announcements are not necessarily consistent with EU law, and violations occurred in at least 43% of the screen websites. This is quite a huge amount of violations, and it shows that the use of AI-based tools is quite effective in allowing the EU to screen all these announcements. And as Peter touched upon a few minutes ago, it allows the authorities to check whether the discounts are real, and whether they do really refer to the reference price of 30 days before, or there may be something more to the issue there. Going on to the next slide, you can see here a chart, an example of a situation. So basically what happened was the following, that the price of this product was discounted until the 2nd of November, but it then increased to 40 euro, 39.99, and remained stable at that value until the 24th of November. When Black Friday hit on the 25th of November, the price dropped to 24 euro, and the web shop indicated as the prior price of 40 euro was the reference price, and that a discount of 40% was applied. However, this was not necessarily the case, because in fact the discount was only of 14% by taking into account the real preceding price. So this information needs to be, as Peter mentioned, very clearly put forward by the online shop, and needs to be displayed in a way in which the consumer can analyze and make an informed decision whether that price reduction was true or not. Several countries have, for example, certain third-party websites that monitor these prices, but this is not sufficient for the EU legislation that we are currently analyzing. And web shops really need to clearly show what was the reference price. So the idea is that the EU is monitoring all of this, and these fines do occur once in a while. They can be made with or without prior notice of the web shop under the existing regulation on EU-wide sweeps. So this is something to be taken into account under the penalty of facing the fines that are introduced through the regulation, through the directive. So passing on to the next slide, I will be talking about what is the new thing with these fines. So until now, we only had national fines, which, as mentioned, were not aligned in terms of value. And in several member states, Romania including, the value of these fines does not necessarily take into account the value of the turnover of the company, but other factors such as the impact on the purchasing power of consumers and other similar aspects. What is new now is that the Omnibus Directive introduces at recital 10 the requirement that effective, proportionate, and dissuasive penalties or fines should be introduced as a deterrent effect to widespread infringement subject to coordinate investigation and enforcement measures in accordance with the CPC regulation. So the regulation is in place for a number of years, but in order to have it, to make it efficient, the Commission considered that these fines need to be aligned and to be at a much higher value. So we are talking only about fines that are widespread and have a EU-wide effect. Yeah, so these are the ones that need to have a minimum value of 4% of the annual turnover of the local entity. Yeah, or have a minimum value of euro 2 million. This is similar to the mechanism under the GDPR. Yeah, so the values are quite similar, but this is a new playing field. Yeah, so the consumer protection legislation is a new playing field for these very high fines that may be applied when infringements occur in multiple jurisdictions. These are just the minimum values, yeah? So member states, when implementing the directive, may set them at even a higher value depending on the circumstances. So in my view, they need to be very carefully reviewed under the national implementation and the criteria for establishing the value of the fines. So if we could go on to the next slide, there are several factors that need to be taken into account when establishing the value of the fine. These are not necessarily something very new. They are established now expressly by the directive. They were taken account previously, at least in Romania, by the consumer protection authorities when establishing the value of the fine. With the difference that previously, so when you're dealing with a national infringement, you usually have a range of the fines under which the authority may establish the concrete value of the fine. So now I believe the authorities will have a higher degree of discretion in establishing the value of the fine, and it will be very interesting to see what the trend will be when establishing such cross-border fines, especially considering that this is a new playing field, and it's obvious that the intention of the EU is to give authorities a mechanism in which they can really puts an end to such practices. Yeah, so we will need to see if these will be objective, if they would be correct and proportionate to the gravity and duration of the infringement, and which were the mitigating factors taken by companies. Yeah, so this is something that existed previously as well. Now it's expressly provided. But actions to be taken are something that are handed over by the authorities. They are ordered to companies, for example, to take out certain products, to stop certain practices, and so on. So this is something to be carefully analyzed when dealing with the Omnibus Directive, considering that the offenses are threatening, especially when dealing with the high value of the fines. So this needs to be very carefully analyzed. We can go to the next slide, please. What to expect? So we saw that the EU is doing these sweeps. They are very effective. They are they are done using AI tools in certain situations. They are done through the cooperation of the member states. And we can expect that authorities may increase the value of the fines that they would apply And in certain situations, the authorities may even come to the situation in which they will request companies to amend terms of use or other contractual documentation, or even potentially business models under the threat of these fines. Yeah, so we need to see what will be the approach of the authorities here. But yeah, this would be, let's say, the worst case scenario of what could happen. Okay, so this would be my part. I hope it was informative, and in case there are any questions, don't hesitate to ask. I will answer at the end of the webinar, and I will quickly turn back to Peter, who will talk about lessons learned. Thank you so much.
Many thanks, Sorin, for this very nice and detailed presentation as well. The case we are going to discuss now was not so recent one, but a recent one, sorry, Christian Louboutin versus Amazon. And this case, while at first sight may appear to be a common trademark infringement case, which is commonly handled by a cease and desist or an appropriate lawsuit, however, looking at it more closely, it provides a very good insight into how the Court of Justice interprets the requirements of duly informing customers as required by online marketplaces. In this particular case, the Amazon was on its platform. There was a trader that was selling fake versions of Louboutin's Red Sword flagship product, and this allegedly infringed Louboutin's registered EU trademark for the Red Sword shoes. And while Amazon, in this sense, was not the seller itself of the relevant counterfeit products, it was involved in the distribution, storage, and advertising of those goods, of course, with providing the relevant platform for it. And so the infringement case was brought by Louboutin against Amazon in Belgium and Luxembourg for the alleged use of Amazon of the registered signs of Louboutin. And this case was referred then to by the Belgian and Luxembourg courts to the CGU for guidance on whether Amazon could be held directly liable under the trademark regulation, Article 9.2. By using the Louboutin trademark, even if by a third-party seller selling counterfeit goods on its platform. And an interesting part was that they tried to focus on the case where in particular, those products were sold alongside Amazon's own products, and shipping, handling, storage, again, some other infrastructure elements or logistical elements were undertaken by Amazon in a so-called hybrid setup or hybrid business model. And the Belgian Belgian Luxembourg courts already had some previous referrals to the Advocate General of the CGU, who rendered his decision in June and considered previous cases relating to online intermediaries' liability. In cases of specifically in cases of infringements of trademark use unlawful, for example, Google France, L'Oreal, Coty Germany, so other previous cases where this particular issue had to be reviewed. And in those earlier cases, no direct liability was established on the part of the online intermediary, so the online platform itself, in terms of trademark infringement in respect of the contents or products offered by third parties on these particular sales platforms. So they dismissed basically this particular unlawful activity or allegedly unlawful activity. The Advocate General's opinion was that an online intermediary cannot be held liable directly for infringements of the rights of trademark owners taking place on its platform as a result of commercial offerings by third parties, i.e. basically saying that if Amazon is, or any online marketplace is, only providing the platform for those products to be marketed. If a third-party vendor, trader, infringes trademarks by its offerings, such as in this case, no direct liability can be established with respect to the trademark infringement itself. And so this particular decision aligned with previous decisions. And so the key consideration for rendering this decision was that in the context of its own commercial communication, Amazon did not use Louboutin's trademark, and this and also the consideration that an average consumer acting reasonably, being well informed, and being an average observant internet user could make a distinction between the two marketing activities. Whereas in the interesting turn of events is that the Court of Justice has superseded, overruled this interpretation, but interestingly, not on the merits of trademark infringement itself, but rather it concluded that such an online marketplace such as Amazon, which integrates its own sales platform and the sale of third-party goods, actually can be held liable for third-party advertisements that infringe a third party's trademark, but only in the sense that the offerings themselves together are for any reason misleading, because the marketplace operator uses a uniform method to present both products, and that is selling and those of the third parties and selling of its own products, which is the case maybe in the case of Amazon, where it has its own branded products as well as sells products of other third-party providers under its own logo and under its own brand and its own operating online platform. And this may make it difficult for consumers to clearly distinguish the origin of each advert and source of and the source of the relevant infringing goods. And in this case, this may give the impression, even in a reasonable and observant consumer, that the operator may be selling the products itself, and so basically using the trademark. So the conclusion is basically that and what can be learned in the light of the recent changes as introduced by the Omnibus Directive is that it's not on the merits of the trademark infringement itself, but definitely online marketplaces will have to be very observant and very careful and considerate to adequately inform and shape their operating mechanics and their platforms, and they're very careful what they communicate to consumers, and not to mislead them in the sense that product offered by them directly and product offered by third-party vendors can be in any way interpreted as one and the same, because they are not. And what we are seeing is that this is generally the good practice now, and we see this very, very clear distinction always displayed on such online platforms that operate in this hybrid operational setup. So this is the key takeaway here. Thank you very much, and open to questions.
Okay, many thanks, Peter and Sorin, for this very interesting introduction to the Omnibus Directive. Before we start with the question session, I would like to summarize, give us a wrap up on the Omnibus Directive, what we have heard and learned so far. First, it's a very detailed, this directive contains very detailed rules with the goal to improve and the transparency and information of consumers. These 4 directives, already existing directives, have been amended. What makes the reading of the Omnibus Directive not always very easy. You have to find the right reference, then to read the rules, to interpret and to understand. So as we can see in the past, that it's not very seldom that one can say that the language of this directive as well sometimes looks a little bit Delphic. what means that it leaves open what is really the meaning of the rules, so that the national courts have some space to interpret. And I'm pretty sure that there will be cases handled by court, and some cases will also go to the European Court in Luxembourg to finally find the right understanding of what the directive really means and has to be understood. I just want to add one thing for you. All the provisions must be complied with by companies, of course, and then the right place to comply with are the terms and conditions, of course. And besides fines, and Sorin has gave us the overview on the fines, we always have also to think on court proceedings on competitors, because not complying with the new rules means a breach of law, and this can be sued by competitors and as well as by association, which are entitled to file lawsuits, injunction lawsuits against the company who is not complying with the new rules. And please be in mind that directive has already been to be applied since May 2022. So it's quite a good period since then. So looking at the questions, we got some nice questions. The first one goes to Sorin. Shouldn't the fine be 4% maximum?
Many thanks, Georg. So to answer Michael's question, the answer lies in recitals 10 and 12 of the directive, which have a wording saying that the member states should set in their national law the maximum fine, which is at least 4% of the trader's annual turnover. So it's a very high value. It's at least 4%, and the member states can even go higher than that, depending on the circumstances. They can set it at 5%, 6%, depending on their take on the issue and the gravity of the offenses. So we will need to see the national implementations and to be reviewed, because they are already available, to be reviewed on a case-by-case basis. But theoretically, it can go even higher than 4%.
Thanks, Soren. So it's not maximum threshold, it's a minimum.
Correct.
4% minimum. It's written down in recital 13 of the directive. Next question, in what way can we consider the Omnibus Directive applicable to banking sector and products offered by the banks? Peter?
Right, many thanks. Banks are always a very specifically regulated area of law, and so it's not just only to the extent that consumers are of course relevant. It has to be, but generally it's more about aligning Omnibus Directive as well as the applicable local jurisdictional finance banking regulatory requirements as well. So I would say that Omnibus Directive lays the groundwork for general requirements of transparency, clear requirements, and consumer providing information to consumers and making pages working well, easily accessible, communications channels open and approachable. But at the same time, it has to be then seen or reviewed in conjunction with the relevant banking regulatory requirements. Definitely.
Okay, thanks. Next question. It's European law, case law from the European Court of Luxembourg. How does the decision in the Court of Justice European Union case of Association of Consumer Organizators Verbraucherzentrale versus Amazon, so shortly called Amazon case, obliging the trader to indicate its phone and fax numbers where they're available, fits into the Omnibus Directive? That's a very good question. Just to remind, as I recall, some years ago, I mean in 2019, there was a case decided in Luxembourg on a complaint filed by the German Verbraucherschutzverband. This is identical to the Schutzverein, or it's an association entitled to file lawsuits, injunction lawsuits against companies, where the case was about Amazon didn't use phone and fax numbers. And the court decided whether that was in line with the then existing consumer protection rules or not. I mean, and they said, yes, a phone and fax number must be presented or indicated on the web as far as they are available. So it's my understanding that this case law is not applicable anymore in so far, but for two reasons. The first reason is fax number. The Omnibus Directive is not speaking any longer about fax numbers, because it's very clear who is still using fax machines for transmitting information and communication. I'm pretty sure that it's very seldom. So the Omnibus Directive does not mention any more fax numbers. However, email address, physical address, of course, and they are mandatory, or not only as far as available, mandatory. What can be understood in that, companies must have email addresses in order to comply with this new requirement. That would be my best guess in this regard. Then next question, let me have a quick look. We have still some minutes left. Yeah, I think that goes to Romania. If there are practices or additional stricter rules in your countries, for instance, higher fines.
Many thanks, Georg. So I think the most important particularity in relation to Romania is the introduction of the so-called commercial record. So this is something that was introduced through Government Emergency Ordinance 58 on 2022, which implemented the Omnibus Directive and put forward this commercial record, which is a centralized database, so an electronic record where all the prior consumer protection offenses of a specific company are stored for a number of 3 years since the date when such offense was discovered by the authorities. This is relevant because it's the first time this was introduced in relation to consumer protection offenses. Certainly the authorities previously knew when they were doing dawn raids, they knew what was the approach of certain companies depending on sector, but now it's an official thing. And it's relevant because it's one of the criteria used when establishing the value of the fine, so the past conduct of that company. And it's also an official record that so it remains there, the offense. So my take on it is that probably this would increase the number of challenges in court for the purposes of expunging the record. Normally, for example, consumer protection disputes arise following a misdemeanor minute that would be issued by the authorities. And since the court tax is quite low, in Romania it's a fixed value and it's quite low, it would be something that companies may consider for the purposes of challenging these minutes and increasing their chances of overturning the consumer protection minutes, establishing fines. So it'll be interesting to see what the approach would be and whether this would in the end generate additional litigation in relation to consumer protection.
Great. More questions? Yes, there's one. What constitutes a case having national relevance, from a consumer protection perspective, which leads to the competition authority having competence investigating the case. Peter, would you like to step in?
Yes, many thanks, Georg. And that is something I can comment on from a Hungarian perspective. So a case under relevant Hungarian rules has national relevance from a consumer protection perspective if the unfair trade practices in question extend or has effects in more than 3 counties in Hungary. So basically having national relevance. Important to note that unfair trade practices conducted online will be accessible for all consumers from the territory of Hungary generally. And these cases almost always are referred to competence of the competition authority due to the how well it extends to or can be extended to any local or anyone in the territory of Hungary. So that's usually what we see.
Thanks. Let me have a quick look. Any more questions? There's one more question. What would allow mitigating the risk of hybrids on that marketplaces like Amazon being held liable for cases such as the Louboutin case? I think it's referring to the one European court case, Peter. That's why I hand it over to you again.
Yes, many thanks. And as mentioned, really, these online marketplaces, using such models, and not just them, but really, I encourage everyone to aim and rework or rethink or at least review their operational mechanics and designs of their webpage, what information is displayed, and in conjunction their terms and conditions as well, to ensure that products sold by them individually and their associated traders who they allow to use the platform based on a contractual setup can be clearly distinguished from each other, and then disallowing any misleading consumer practices or issues on the side of the consumer.
Great. We are good in time. No more question left for now. So then it's time to close this webinar. We've seen still a new territory, and in the coming months we should get further clarity on how the directive works in practice. If you have any further questions or observations from your practice, feel free to reach out Wolf Theiss or one of us 3 directly. Would like to thank you for your attention and time, and have still a nice day today. Thank you very much.